Welcome to the Boomers Bucks and Bling podcast, where we turn retirement planning into a bit of a thrill ride. I'm your host, Carl Spiteri, and each week we'll dive into everything from reverse mortgages and staying put in style to Medicare, Social Security, and home safety. But wait, there's more. We're not just going to talk all about money and business. We're going to add some sparkle, some bling, as we chat with travel pros, party planners, and a lot of different topics that's going to help you make the most of your golden years. So grab a cup of tea or whatever it is you want to drink, get comfy, and let's make retirement planning an adventure of a lifetime. Welcome to this edition of Boomers Bucks and Bling, where we try to make sense of the retirement process. Today we have our special guest, Danielle Barger. Danielle, why don't you tell us a little bit about yourself and your company and all that kind of stuff?
Morning, Carl. Thanks for having me today. I'm Danielle Barger, and I am a founding partner with Barger and Batiste Law here in San Diego. And we are a boutique firm specializing in all things trust and estates. So we do estate planning, estate administration, probate, with a little bit of tax and business law kind of thrown in there for some flavor.
Wow, I bet you're busy.
We are busy. We do a lot of planning. I love when I have clients who want to be proactive and make sure that their estate planning is all in order so that their children and loved ones don't have to go through everything. So I love that. But we're also busy with people that don't do the planning, and we have to go to court and fix that up, tidy that up. So we keep busy, and we just love working with our clients through those processes.
So I guess probably the number one question, why have a living trust?
I think that it's really billed as it's a way to avoid probate, which is 100% true. But something that a lot of people don't realize is it's got some great incapacity planning built in as well. So if you pass away and you have no documents, there is a default set of rules that will apply. The state of California says that your assets will go among your spouse and children. If you don't have any of them, to your parents, to your siblings, and there's an order of succession. So your money will ultimately get there. It's going to cost some money, it's going to take some time. But another thing that people often don't think about is incapacity. Most people don't have the luxury of just passing away in their sleep. We'll have a time where we are incapacitated, unable to manage our own affairs, and that's where our loved ones come in. And if they don't have documents in place, then we got to go to court, right? And so you hear about high profile people. Britney Spears was a big one, didn't have anything in place, had to go to court to get her loved ones to be in charge. So incapacity planning and probate avoidance is really the main reasons why people should engage in estate planning. It also allows you to decide what happens. You're not just relying on the judge and the default rules.
Yeah, I know in the world of reverse mortgage, which we do quite a bit of these days, we're finding I've actually have two cases actively where we have one partner that it doesn't have the mental capacity to sign, and we're running into real challenges with that. I guess it's really important to get this done sooner than later.
It really is. And there's a false understanding in the general public that if you're married, your spouse can do things on your behalf. And it's not true. So if me and my spouse own a property together and I become incapacitated, it's like frozen. He can't just do things for me. He can't do a mortgage or a reverse mortgage. And so it's really important that those things get done. And you mentioned reverse mortgage, and I love reverse mortgages. I think they're a
Do you? I
wonderful
didn't know that going into this
opportunity.
call. That's great.
Yeah, and I think they kind of got a bad rap in the, last few decades because there were a lot of bad actors out there. But I think it's a great way to make sure that somebody can tap into the equity of their home and live the life the way that they want in the manner that they want. And the one thing that I will say about a reverse mortgage is it's extra, extra, extra important that that person has a trust. Because what happens when that person passes away, Carl? How long does the bank have to deal with things?
12 months maximum. And
And
it's 6 months with 2 3-month extensions, actually.
Exactly, right? And so going through the probate process, if somebody doesn't have a trust, can easily exceed that. I was reading an article yesterday that the average time in probate is about 18 months. 18 months is longer than 12 months, right? And so that means we've got a
Let me do the
problem.
math on that, yeah.
Yeah, and so we got to make sure that those things are in place so that you're not setting up your children to deal with a big mess.
And I know there's issues with reverse also on deed transfers. When we do a reverse mortgage, we can take title in a trust, but we can't change title, or it's harder to change title once we have the reverse mortgage and wanted to title it into the trust.
Yeah, definitely best practice would be to get your trust in place, make sure that your reverse mortgage company is aware that the title is held in the trust, and they go through their due diligence to make sure that there's no issues. So it's all nice and clean. There's also, and maybe I'll just mention this right quick, there is a transfer on death deed that some people will do. And basically it says, okay, I, Danielle, own 123 Main Street. And maybe I don't want to do a trust. And so I just do this transfer on death deed, which essentially adds a beneficiary designation to my house. It was something that came about, I'm going to say maybe 2017, and it continues to be extended. Those also have a lot of problems with them. And so I kind of want to make this little plug for it to not do that without advice of attorneys, because that can cause some issues. So imagine your client, Carl. Let's say Sally has a property, she's got a reverse mortgage on it, and she files a transfer on death deed, which essentially sends the property to whomever she selects. That just adds a little bit more of confusion and complexity that I don't really like.
Okay. So what type of confusion and complexity does it add? I mean, just a couple of things.
So let's say that my property goes to my daughter. Well, first, my daughter is only 17. So a lot of people don't realize that sticking a minor in that role is a problem. It's a do not pass go, let's go see a judge in probate court. But putting that aside for a moment, let's say she's 18. So I die, and now there's basically a lien against the property. And the title companies usually do not let you sell the property until 120 days has passed. So now my daughter, because I'm dead, right? She has this deed that says she owns it. Title company's giving her a hard time. She can't turn around and sell it. And so now we've got the reverse mortgage company saying, hey, you got to sell it. You got to do something. And it can cause some more delays. And delays just don't bode well for wrapping up that reverse mortgage in the way that it was designed. So there's a place for those transfer on death deeds, but I would say that it's not in the context of a reverse mortgage.
I would imagine it's probably not the best thing in the world for a forward mortgage or a traditional mortgage, because
True.
now you have 120 days that have passed, and there's usually a foreclosure of some sort, either filed or getting ready to be filed, which
Yeah,
adds
because the
time and
title
money.
companies, they get a little nervous and they're like, is this really done correctly, right? Unfortunately, there's a lot of fraud that happens to our elders, and there's shady caregivers that get these deeds signed and notarized. And so the title companies, when they see this, they want to wait 120 days to make sure there's no problems. And so that's just something that I had a client, maybe 8 or so years ago, and she's like, yeah, okay, so as soon as dad passes, the house is mine. Right. I literally, Carl, was called an hour after he died. And she's like, you said it was mine as soon as he died. I'm like, well, yeah, it is. However, you need a death certificate that takes a little bit of time. You have to record things to perfect the title. And so all those things just make it a little bit harder. So going with the gold standard of a revocable family trust is the way to make sure that now your assets will pass without probate. You're not going to have a delay. It's private, and you're going to save a lot of time and money in the event that you do become incapacitated as well.
So tell us a little bit about the durable power of attorney. what does that bring into, because that's usually part of it, the living trust, correct?
It's usually part of your estate plan, but
Okay.
the durable power of attorney is a document that basically says, I, Danielle, appoint Bob to be my agent. And Bob can stand in my shoes and do all things that I could otherwise do. Now, that word durable in there means that if I subsequently become incapacitated, Bob still has that right. Okay, so it lasts through my incapacity. That's what that durable means. Now, when you're dealing with powers of attorney, there's basically two flavors. There's the immediately effective. I give you, Bob, the right to do all those things right now. I have capacity, but I'm going to do that because I would like you to help me. Maybe I'm not very mobile and I don't want to go to the bank. Then there's the other kind, which is called a springing power of attorney. This one jumps into life the moment that I become incapacitated. So until that time, Bob has no rights. So there's two different kinds. Typically, those powers of attorney are to deal with non-trust assets, and then the trust will deal with trust assets. That can be very confusing. I think that's the number one piece of information that people don't understand. So let's say that you, Carl, have a trust and you also have a power of attorney, and you have now lost capacity. You have dementia. Well, assuming your home is in the trust, your trustee can do all things regarding that trust asset. If appropriate, they can borrow money, take out a mortgage, and whatnot. The power of attorney is usually reserved for non-trust assets. So if you have an IRA account and you need to take your RMD and you can't physically call and say, hey, I need to do that, your power of attorney can do it. I highly recommend that the trustee and the agent under the power of attorney are the same individual. That way, if you become incapacitated, you have one person that can do both things and you're not trying to coordinate. So the power of attorney is not part of a trust, but both the power of attorney and the trust are part of an estate plan.
Okay. And then what about healthcare directives? That's to me, that seems like it'd be very important to me as I'm getting older. I'm going, who's going to make these choices when I can't?
Exactly. The healthcare directives are usually also part of an estate plan. They're going to dictate who's going to make healthcare decisions if you can't make them yourself. That is where I think a lot of confusion stems, because I'm married. If I have no documents and I become incapacitated, my next of kin, according to state law, is my spouse. And so my spouse can come in and make decisions. But maybe my spouse is not the person that I want to make those decisions. Maybe it's my best friend or my mother or my sister. And so the healthcare power of attorney, which we typically call in California the advance directive, is an integral part of the estate plan so that you can decide who's making the decisions and what kind of decisions you want, right? I was talking to somebody the other day and she's like, oh no, I want a hypochondriac to be my agent, because I want to make sure that they're asking all the questions and they understand everything. I'm like, oh yeah, you don't want to pull the plug because you got a paper cut. I get it. So it's important to make those decisions. The default rules in place, if you don't have them, are not as bad, but it's still super important. And I'm pleasantly surprised that a lot of medical facilities will ask about it, encourage it, especially when my clients are going to go have surgery or whatnot.
A lot of them will even offer notary inside the hospital, from what I understand.
They will, that's correct.
Yeah. Wow. It's a lot of information. What else can you enlighten us some more? I don't even know what to ask at this point.
So, one of the things that I find problematic is that people will do a trust and then they set it on the shelf and they don't touch it again.
Yeah.
So a trust is a living document, right? It's even in the name, right? It's often called a living trust. Now, the reason it's called a living trust is because you do it while you're alive or during your life. But people in the 90s, when trusts became popular, they would go to maybe a show, a dinner, and they would hear about a trust and how it's the best thing since sliced bread. You get a trust and you're good. Your kids don't have to worry about anything. Well, that's not entirely true. Okay. So getting the trust is the first step. The next step is funding it, making sure your assets are actually in it, right? How many times have you pulled title and you see that Sally Smith owns this property and you go, hey, Sally, I thought you said you had a trust. Oh, yeah, I do. I have a trust. I did it. Yeah, but your house isn't in it. So what that means is when Sally passes away, we have to go through probate. And that is the same answer for all of your accounts. So making sure that you are talking to your attorney and working with your team to make sure it's funded and everything's pointed to the trust or in the trust is really, really important. And then you got to look at it every few years. I would say maybe every 3 to 5 years, you want to look at it and make sure it properly reflects your wishes, right? People will do this and set it aside, and then I'll talk to them in 5 years and say, oh, you know, you named Joe and then Sam. Oh, I did. I forgot. I haven't talked to Joe in 3 years. And, Sam is now really Samantha. And I don't really like this person anymore. And so those are things that really have to be revisited. And that's why it's important to have an attorney that you know and trust and you're comfortable working with so that you can reach out to him or her every few years and keep it up to date.
Yeah. One of the most common challenges that we face in the mortgage world is that people have a trust and they don't, again, the house is not titled into the trust, or they've done a refinance of some sort, and it's kind of a hassle in my world to take title in a trust. We have to get the corporate attorney to look at the trust, and a lot of times people don't want to share the trust or the trust cert. And then the attorney has to say, okay, you're good, and then it's fine. But if they don't want to take that step, for instance, 2021 when rates were at 2.5% or whatever, and everyone was so busy, no one wanted to take that extra step, and so they just funded it in the personal names, and that's just not, again, that's not funding your trust. It's like not having a trust, but essentially. And then the other
Exactly.
issue we run into sometimes is where the property's not in a trust, and they do the 1-800 get a trust, where they don't have attorney involved, and they put the property into the trust, but they don't get title insurance for that. And that can become a challenge as well. So it's really important to do it correctly. Because again, once you're here, we can ask questions. As soon as you're not on this earth anymore, it's pretty hard to ask questions.
Exactly. And there's a place for the do-it-yourself stuff in every industry. And I tell people like I could, see where there's certain clients that do it themselves and can do it okay. The problem is the questions that you don't know to ask. If you've got 3 kids and you say, I give it equally among Alan, Betty, and Carl, well, what happens if one of them is not there? And so there's default rules that will pick up in the event that, something happens and one of those people's not there, but that might not be what you want to happen. And so talking through all those nuances is really important so that we can make sure we understand your intent and can properly document it. One thing that I'll also mention is naming co-trustees. This is something I see a lot of where people will create their trust and they go, I have 2 kids. So let's name my 2 kids, daughter and son, to be co-trustees. And that way they don't think I'm trying to hide anything. And I go, okay, yeah, do your kids get along? No, they don't really get along. They don't talk, but I'm sure they will if I die and I need them to. Okay. That doesn't happen, right?
Never.
And so just talking through all those important details is super important to use an attorney to do that. Now, there is a new rule that passed April 2025 of this year, which essentially says you can avoid probate if all you have is a house and it's worth less than $750,000. Now, that doesn't really go super far in California, especially in San Diego. And so I can see how that rule was put into place and it's got its appropriate uses, but there's a lot of chatter out there that maybe people don't need a trust because of that. So I thought I'd throw out there as well that getting professional advice is really important.
Yeah. That it is. I mean, again, this is so important. We've all worked so hard to get to whatever stage in life we've gotten to in retirement, and it's just making smart choices, right? I preach that to everybody I speak to. You know, not that it doesn't matter what choices you make, but at least you're here and you're making the choices. It's so important to take care of everything you have, and why give a big part of your accumulation over the years to attorneys, no offense, but to attorneys and to the courts, right? If you just address it in advance, then you're everything you've earned at least is going where you want it to go.
Exactly. Absolutely true.
So,
Yeah.
well,
And
Danielle, go ahead.
you talked about cost, right? And all the money going to attorneys. And you're right. I would much rather make my fees in another way. And so let me just kind of touch on that for a moment, because it's
Okay.
always in somebody's mind, right? If you have to go through probate, the probate fees are set by statute. It's 4% for the first 100,000, 3% for the next 100,000, and then 2% for the next 800,000. Okay. So you're in the over $20,000 range for your typical $1 million house. And that's going to go to the attorney. It's also going to have a matching sum to your executor, who could be one of your children. Okay. So now you're way in for tens of thousands of dollars when you could probably spend 4,000 plus or minus a couple thousand to do a very comprehensive trust. So you've saved money and you've saved time. So I thought I'd throw that out there so we know what we're talking about. It saves money. And then you have a relationship with somebody that you can go to, your kids can go to when they need that kind of help.
Speaking of needing help, why don't you tell people how to get a hold of you if they do need help?
So again, my name is Danielle Barger, Barger. You can Google me, I'm all over the place, but our email, or I'm sorry, our website is www.dbsquaredlaw.com. You might say, what is that all about? Well, my best friend and law partner, her name is Danielle Batiste. She goes by Danny. So we both have the initials DB. So we're DB Squared Law, and we get your estate plan squared away. So again, dbsquaredlaw.com.
Thank you again. Have a good day.
Thanks, Carl. Have an awesome day.
Tuning in to this episode of Boomers, Bucks and Bling. We hope we've managed to mix a little enlightenment along with fun. If you enjoyed our conversation, don't forget to hit the subscribe button so you'll never miss out. And if you got a moment, drop us a review. It helps spread the word and keeps us motivated to continue. Got burning questions? Hot topics you want us to dive into? Let us know on our website or social media. Until next time, Carl Spiteri here to remind you to tackle retirement with a big smile and a whole lot of energy.